All rise. Lake Circuit Court is on session. The Honorable Judge George C. Paris presiding.
You may be seated.
Afternoon, Judge.
Good everyone. We're here in the matter of medical specialist defendant versus Franciscan Alliance, Inc. 45 CO1 1210 PL 102. For the record, would everyone identify themselves and who they're representing?
Your Honor, John Reed Abrahamson reading bills on behalf of the plaintiffs, Drs. Layous, Sethi, Tassi, and Dr. Jordan and Dr. Patel.
Okay.
Good afternoon, Your Honor. Harold Abrahamson on behalf of the plaintiffs.
David Jensen on behalf of medical specialists.
I'm Robert Anderson on behalf of Franciscan Alliance.
Melissa Saratakis on behalf of medical specialists.
Brian Jehan on behalf of medical specialists.
All right. We're ready to proceed.
Your Honor, I think we are. Please support, Your Honor.
I mean, we have several things going here.
That's what I was going to say first. And I don't know what order the court wants to take them up in. I think there are various motions to strike by both parties. We also have a motion to compel some production of some patient lists from medical specialists and or Franciscan. And we also have another issue is the document we had faxed to the court yesterday, filed this morning. It's on a verified motion to permit the filing of the second supplemental designation of evidence, which was material that my firm had only received yesterday in the state of Indiana. And we had faxed that to all counsel of record. And like I say, filed the verified petitions officially in court this morning. It's not like faxed yesterday. So we've got those issues. I think the main issue we're here for today, how dependent it is on the others, is not certainly for me to decide. I think there's certainly some interdependence between them all. But it's the motion for summary judgment that we have filed, the plaintiffs, on behalf of all five of the doctors regarding the complaint for declaratory judgment on the efficacy of the non-compete and the other covenants in their contract.
Right, there was a problem with one of the motions. I had responses, but I didn't have the actual motion because I guess the case was somewhere else.
I think Judge Van had the files for some time. Or which one is it that the court does not possess?
I have it now,
Okay.
but I didn't have it. To be honest, when we had responses, but I didn't have an initial motion.
Your Honor, from the standpoint of the defendants, we have no objection with counsel proceeding first with regard to the motion for summary judgment.
Okay.
Your Honor, and I think the other issues, maybe the answer to that is concerns what evidence the court will look at in regard to the attachments and designations of evidence, summary judgment, and like Mr. Jensen said, I think that can be brought up after these arguments are.
Okay.
So, Your Honor, if I might, I'll start out by stating that back in what led to this particular dispute was back in October of 2012. Defendant medical specialists entered into an asset purchase agreement with the purchaser of Franciscan Alliance. It was an asset purchase as opposed to a stock purchase. Prior to the purchase taking place, a great many things happened. There were a lot of meetings. There were some town hall style meetings. I think some of them held by Dr. Stemmer, who was here. I missed him. I'd seen him earlier. And basically, a lot of those meetings were informational. What would happen to the, I believe, 56 practicing doctors and medical specialists as a result of the asset purchase agreement. And probably the most important thing that happened during that time as far as this case is concerned, the agreement that was signed on October 1st, 2012 by all the parties and fully executed and taken effect as of that date was the fact that the asset purchase agreement contained a specific provision that stated as long as Franciscan is able to obtain, or medical specialist is able to obtain for it, 48 of the approximately, I think it was 56 physicians that were practicing as medical specialists, that the deal could close.
So 48 doctors stayed with,
48 doctors transitioned to Franciscan.
Okay.
They were presented, all the doctors, including the plaintiffs in this case, were presented with amendments of their contracts that held that those contracts would be being assigned to Franciscan Alliance, and that the employees would become employees of Franciscan Alliance and not be employees of medical specialists. The original contracts with medical specialists, we maintain the reason that was done is because the original employment agreements did not contain assignability provisions. In other words, none of those 48 doctors, certainly not the 5 that I represent here, had any, well, I shouldn't say intention, but did not certainly have anything in their contracts. And we don't know of any of the other 48 contracts either that had assignability provisions. That is why they were presented with the amendments to their contracts. And it was sign it or don't sign it. I'm sure there were other negotiations, potentially bonuses and other things that were discussed. I don't think that's the issue here. What's at issue here is what happens to the doctors who don't sign up with Franciscan. Those are almost all are my clients. There are a couple of others. One who didn't have a non-compete, one who I don't think has filed suit. I don't know if they intend to go elsewhere or not. However, what we did, Your Honor, after the contract was signed, of course, we filed our complaint for declaratory judgment on October 2nd of 2012 and duly served it. And what has happened since then has gotten a little interesting, and I'll get into that as this argument proceeds. I will tell the court that all of my 5 plaintiffs, I call them my 5 plaintiffs, I should say all of the 5 plaintiffs, have filed or submitted to medical specialists their resignations, assuming that they even had employment contracts at the point of the asset purchase, which we maintain that they do not. If the court were to find that those contracts were in effect, we wanted to make certain that we had followed those contracts and submitted our resignations. We're required by the employment agreements to submit those resignations before December 31st of the preceding year that we intend to leave. And then we must not leave until after June 30th. In other words, we won't be free from those contracts until July 1st of the following year, which is 2 weeks from now, roughly. So in any event, that's sort of the build-up to how we got here today. We stayed in our offices working as though we were still working for medical specialists. In the event that the court were to find that our covenants not to compete were enforceable and that there was an existing contract, we knew we would be here one day like we are right now today before this court in equity. And in order to receive equity, you must do equity. I think that's axiomatic. Equitable considerations. We did not want to just go out, open an office, and start seeing patients for multiple reasons. One is, I don't think that's equity. Indiana has passed years ago the Indiana Declaratory Judgment Act and provided Trial Rule 57, which states that before you have necessarily a case in controversy, you want to know what your legal rights are, go to a court of competent jurisdiction and find out before you do something that could be injurious to someone or to yourself. That's the avenue we chose to take. We felt it would be perhaps rushing the issue or not permitting the court an opportunity to consider all the facts and all the law. So we've come here today, we hope, Your Honor, we tried very hard to come here today with clean hands so that we let the court know that we just want the court to consider the law and the facts and give us the ruling that it thinks is fair and correct. And the other reason we didn't go away and just open our own practice obviously concerns patient care. Medical specialists, former company, is what it said it was. All of the doctors there specialized in particular areas. They weren't general practitioners, or family doctors necessarily. Pulmonology, immunology, allergy medicine, all down the myriad of different specialties that a family doctor or general practitioner might refer someone to if they suspect someone might suffer from lung cancer or emphysema or a substantial infection that may not be something you deal with in a doctor's office. You refer them to a specialist. The doctors here, Dr. Jordan is a dermatologist who's also certified to do Mohs surgeries, which is a very complex medical procedure that deals with treating skin cancer. is the least invasive way of removing skin cancer lesions and taking away the problem and doing the least injury to patients. Doctors Layous and Sethi are pulmonologists, and Dr. Patel is an allergist and an immunologist, and Dr. Tassi specializes in infectious disease. Now, had we just left and went down the street and opened up a new shop, it would have been very confusing to the patients, probably, for one. And these patients aren't patients with maybe a cold or a headache, or these patients have serious medical conditions, Your Honor. I mean, they range from lung cancer, emphysema, COPD, HIV, AIDS, skin disorders, including skin cancer, and the list obviously goes on and on. Those materials, of course, are contained in my brief. The question becomes, what is the effect that the asset purchase agreement had on the covenants not to compete and had on the contracts as a whole? We, of course, claim that the contracts were breached by medical specialists when they finalized the asset purchase agreement because the conditions of our employment changed so radically. We really were working for someone else. The way it worked was Franciscan did all the billing and collection and charges. We used their computers. Franciscan bought everything. Let me point that out first. Franciscan bought medical specialists, equipment, office buildings, patient files, goodwill, everything that goes along with conducting medical practice. Franciscan bought it all. And in buying it all, also restricted medical specialists at that time, and for the next 7 months, from competing in a 25-mile geographic radius from their main office, medical specialist's former main office, which was at 45th Street, Calumet Avenue in Munster, Indiana. That 25-mile radius, as the board I'm sure is aware, basically eats up the whole county and dips into some other counties across the state lines. However, that having been done, my parties here, the plaintiffs, were in a position that everything they work with, all the equipment they use, all the employees they work with, everybody was transferred to medical specialists. I should say everybody and everything. There was nothing left of medical specialists at that time except the shell professional corporation that existed previously. They did not elect to go with Franciscan for a multitude of reasons. The reasons actually don't matter. However, some of those reasons were. And I think well, I shouldn't say they don't matter as far as the asset purchases. In fact, they matter as far as the breach of contract is concerned because they're now working, if they went under Franciscan's umbrella, instead of for a mid-sized independent medical specialty provider, they would now be working for a multi-billion-dollar 13-hospital Catholic religious hospital system that none of them elected for. And Your Honor, there are 3 wholly independent reasons that the court can use and that the court can find that the plaintiff's claims are correct and that the covenants to compete cannot be enforced against them due to the way this deal was structured. Is one, the fact that it was an asset purchase as opposed to a stock purchase. 2, concerns the public policy ideas and the patient care concerns that I think are really paramount in this case. If we forget about all the money and the patient files equal money and all these other things that have to do with the finances of both organizations, patient care is the thing that often gets overlooked in these disputes. And the Indiana Supreme Court, of course, disagrees with that position and has stated so, because they have said in cases concerning physician non-compete agreements, they have to be looked at with a particularly careful scrutiny because of the overriding public policy concerns with patient continuity of care, with the ability of patients to even find their doctors, to have open lines of communications with their doctors without being worried about violating non-compete provisions and the like. And that's independent idea and reason number 2 as to why the plaintiff should prevail in this case. Number 3, is based upon the fact that it is our position that the contracts themselves, their employment agreements that they had with medical specialists, were null and void because they were breached the moment that the contract for the asset purchase was signed. Okay? So those are not cumulative reasons, they're not factors in the test. They're three independent reasons. If the court finds any one of them to be that we will be correct on that point as far as the law and the undisputed material facts are concerned, we can prevail on any one of those three items without having to prove all three. I think we do prove all three, and we'll go through that as we go. What I want to do before we get into each of the three individual grounds and what our arguments are concerning that, and I don't want to, Your Honor, I don't want to belabor the briefs. I know the court has read these briefs. They're long, they're detailed. If you take our briefs and their briefs together, we're in excess of 100 pages of just legal argument. And then as the designations to that, it's a lot more. I don't want to go over things the court has already read and looked at. I just want to highlight some points. But as an initial preliminary matter, I want to try to dispel the claim of Franciscan Alliance before we get into the medical specialist issue. Franciscan Alliance is a stranger to the employment agreements between the plaintiffs and defendant medical specialists. They have been permitted to intervene in this case over our objections, and that's okay. They, I think, at least stated that there might be some protectable interest because of the way the contract was structured with medical specialists. We don't believe that exists. The only part of the Franciscan medical specialist contract that concerns the non-consenting physicians Your Honor, basically states that the non-consenting physicians will be treated as, I think really what it says is as Franciscan employees and medical specialists will do everything they can to maintain and keep the goodwill associated with those physicians' practices for Franciscan. In other words, what it says is, we know that they didn't consent to become part of Franciscan. We know they wouldn't sign the amendments to their contracts to make them assignable to Franciscan. But we want the benefits of all of their service, and we want the benefits of their non-compete clauses. I think that is a really interesting way of working around the legal fact that you can't have those employees. Those employees are not forced to work for a stranger to their original employment agreement unless they specifically made it assignable or they specifically signed an amendment to do so. I think the law on that is absolute. That comes up in SDL Enterprises versus DeReamer, 683 Northeast 2nd, 1347. And that's the Indiana Supreme Court case from 1997.
What was that?
I'm sorry. That's a Court of Appeals case from 1997.
What was that again?
SDL Enterprises.
Mm-hmm. What was the site?
683 Northeast 2nd, 1347. And the reason for that, Your Honor, is, and what we talk about in SDL, is that personal service contracts is what an employment agreement really is. And they're extraordinarily personalized arrangements between an employer and an employee. Because an employee is willing to bind himself to one employer does not mean he is willing to suffer the same restrictions as a stranger to the original obligation. Here, Franciscan is the stranger to the original obligation. The plaintiffs should not have another employer forced upon them without their consent. They did not so consent. Franciscan got, in this purchase, exactly what it negotiated for. At least 48 physicians. Presumably they got them because they closed. I've never heard that they didn't, and none of the briefs and materials indicate that they didn't. For those 48 physicians, the real estate, the goodwill, the patient files, all the equipment, they paid $23 million. That's what Medical Specialist Inc. PC received. So they've gotten the benefit of their bargain. The fact that they tried to maintain and keep the physicians that didn't sign under their control doesn't matter. It simply doesn't legally, it has no force or effect. They agreed to work together to try to reach an end that would be keep these physician services for us as long as you can. And we want the benefits of all their non-competes, even though they didn't agree to be employed by us, or to work for us, or to be restrained from competing with us. We agreed to be restrained from competing with the medical specialists that we worked for and started working for in the mid to late 2000s. That includes all of the plans. Your Honor, I'm sorry, I didn't have to say it earlier, but Section 1.4A2 of the Asset Purchase Agreement provides that if any of the providers, including the departing physicians, do not execute and deliver an amended consent to assignment of their written employment agreements when medical specialists will reasonably, it says then medical specialists will reasonably cooperate with Franciscan, and Franciscan may reasonably request in an effort to obtain for Franciscan the benefits of each non-consenting provider's employment agreement with medical specialists after closing. Seems specious at best. Your Honor, I think that, as far as I'm concerned, I think, unless the Court has any other questions about does Franciscan have the right to enforce the agreement, it's fully addressed in our brief, and I think I've highlighted the points here that I would discuss in regard to that. It would be no different than, you don't even have to consider really the physician context in this regard. It could be any other employee. My employer sells, I work for Company A, my employer sells all assets, equipment, goodwill, and everything Company A owns to Company B. Now Company B says, Company A, you've got to help me enforce their restrictive covenants, even though they don't work for me. And they never agreed to stay out of my area. They didn't, those physicians didn't agree to a 25-mile radius from their office. Medical specialists did. So now I'll move on now, Your Honor, to the three independent grounds upon which the Court can rule that the non-compete agreements were unenforceable. The first being the fact that this was an asset purchase. Your Honor, the fact of the matter in this case is that there were two different ways they could have structured the sale here. They could have done a stock purchase. Franciscan could have bought all the stock of Medical Specialists Inc. PC from all of its stockholders and could have run it just as Medical Specialists Inc. PC had been run for many years before that. Dr. Stemmer started this group. Had they done that, they could have even changed the name to something else. And honestly, I don't think it would have mattered. As long as it ran the same and didn't become, an artifice for what really was an asset purchase. So they specifically chose the asset purchase way of doing business. The reason for that is fairly simple. In a stock purchase, the purchaser cannot avoid debts, obligations, liabilities, whether known or unknown, of the company whose stock they're buying. If you only buy the assets of the corporation, you specifically, as Franciscan did here, specifically exclude debts, liabilities, and obligations, whether known or unknown. So, by doing the sale that way and conducting the purchase that way, they've made a choice. The choice was, we want to limit our exposure to any possible debts and liabilities of medical specialists. We just want all the benefits. We don't want the bad parts. Along with that comes a particular price. You also don't get to automatically take all the employees and run the company like it used to be run necessarily. Okay? That is, and it's been characterized by the defendants as this is our gotcha argument because it was an asset sale. You can't enforce the covenants. Certainly Franciscan can't enforce them, and medical specialists can't enforce them either. Well, I guess I agree. It is a gotcha argument because it's a correct argument. And the Indiana Supreme Court has stated it's a correct argument, so is the Indiana Court of Appeal. There's another case, Your Honor, Norland, that we have, and I can actually end up a copy of that case. Save the court some time. Your Honor, if I'm not approach, I've got a copy of the Norland. This is Norland versus Faust. 675 Northeast 2nd, 1142, Court of Appeals, 1997. In that particular case, Your Honor, there was an entity called Faust Eye Clinic, and it was a sole proprietorship run by, of all people, a Dr. Faust. He had an employee, last name Norland, who decided that because Dr. Faust went from being a sole proprietorship, he converted that sole proprietorship into a professional corporation called Faust Eye Clinic PC, that because his agreement was with someone else, and not by Faust Eye Clinic PC, that he no longer had to honor any of his non-competes, non-solicitations, or anything of the like. The court there held that was merely a change of form from one type of entity to another. It was not what I would call certainly nowhere near what an asset sale does to a company, strips it of all its assets and leaves behind a shell, which is what happened here. Everything was exactly the same. Everything. Except that the company name changed. There was a PC on the end of it that had no impact whatsoever on Dr. Norland. And the court held there that he could not evade his non-compete provisions. So, Your Honor, what we're left with is the test when the asset purchase is entered into. In order, I should say it this way, in order for medical specialists to show that they can still enforce the covenants, even though they've sold all their assets, is to show that they have a protectable, legitimate interest in enforcing the covenants. And it's important that that word legitimate is there. You can't just say you have an interest. The courts have held you must have a legitimate interest. At the time of the sale, there was nothing left of medical specialists. All contracts had been sold and assigned, including all the employment contracts. We have stated before, all the equipment, all the real estate, all the offices, everything was gone. Now, about 7 months later, and you'll notice in the memorandum in opposition to our summary judgment filed by medical specialists, they say, but aha, I now have a protectable interest, although I didn't have one back on October 1st of 2012, because I have an interest in these 3 medical director agreements of Dr. Sogard, Dr. Dumont, and Dr. Daniel Smith, 2 pulmonologists and infectious disease doctors. For one thing, you'll see in our brief, Your Honor, we pointed out where those doctors are separately listed. So I shouldn't say those doctors. Those doctors' contracts are separately listed in the asset purchase agreement in one of the schedules attached thereto, which lists all the various items of property sold. It's a completed inventory of everything that was sold, including those contracts. So medical specialist seeks to now protect something and say they have a legitimate interest in protecting it, but they'd already sold to Franciscan. They also say, lo and behold, now that we have to come up with a legitimate protectable interest, we are going to go ahead and have 2 physicians that Franciscan is going to partially waive the non-compete provision that they have with medical specialists and allow medical specialists to hire 2 doctors. One, I believe, is a pulmonologist. The other, I believe, is an infectious disease doctor. One of them, they have actually already hired. I think that's Dr. Chi. That was, Your Honor, I believe, that agreement was entered into between medical specialists and Franciscan for Franciscan to waive that non-compete 2 days before defendant's response was due for a motion for summary judgment. That's why I say it's important to remember the word legitimate protectable interest. I don't think that's legitimate. I think, and I don't mean to be rude or crass, I think that's a ruse may be creative, may be very bright. I don't think it defeats the equity position this court sits in on this case to say what is real and what is fictional. The agreements are real and they're really signed. But let me tell you this. That agreement with Franciscan and medical specialists to waive their non-compete provision says exactly why they are doing it. And the why, talking specifically, Your Honor, and you'll see this is at Exhibit A3 of the defendant's designation of evidence. Document entitled Agreement. And this is the agreement between Franciscan and medical specialists to employ, for medical specialists to be allowed to employ some doctors. Whereas, Keenan Atasi, Karen Jordan, Fadi Layous, Sanjay Patel, and Praneet Sathi, each a departing physician and collectively the departing physicians, each signed an employment agreement with medical specialists prior to medical specialist execution of the asset purchase agreement. And whereas, each of the departing physicians declined to accept employment with Franciscan and has filed a lawsuit claiming, among other things, that despite the fact that medical specialists invested significant funds in developing their practices, supported them financially while they developed their practices, and introduced them to patients and patient referral sources, the respective restricted covenants contained in their employment agreements with medical specialists are no longer enforceable. And whereas each of the departing physicians has expressed a desire to practice medicine in their respective areas of expertise within the restricted area described in the restricted covenants of their respective employment agreements. Whereas, Franciscan and medical specialists desire to protect and preserve the goodwill associated with the departing physician's practices that was developed, financed, and nurtured by medical specialists. In other words, we're entering into this agreement to defeat this lawsuit. Not for a legitimate business purpose that requires the protection of the restricted covenants. This is maybe what's more unusual about this last-minute agreement to try to save this case. Paragraph 8 on page 7 of Exhibit A3, term and termination. When can Franciscan say, okay, we're not happy with this deal anymore, we've made with medical specialists, these arrangements are over, maybe we've gotten summary judgment, we don't need them anymore? Okay? Term and termination. The initial term of this agreement shall run from the date of execution through June 30th, 2015. Thereafter, this agreement shall automatically renew for 1-year terms unless either party provides 90 days notice of its intent not to renew. Here's the good sentence. Notwithstanding the foregoing, Franciscan may terminate this agreement for any reason or for no reason upon 90 days notice to medical specialists. So this agreement to allow medical specialists to compete with Franciscan that they say would give them a protectable interest, Franciscan can cancel it 90 days notice for no reason whatsoever. I suspect that 90-day notice provision would run the moment this court said, yes, that's a protectable interest, here's your summary judgment. Goodbye, agreement. I don't think that's enough to overcome the fact that we don't have remaining protectable interests. There are also the three doctors I mentioned earlier, other than one they've hired and one they say they plan on hiring, hasn't been hired yet. There are doctors, it was Dr. Dumont, Dr. Smith, and the other pulmonologist whose name currently escapes, Dr. Stokar, that they have and intend to continue to have and plan to have medical director agreements with other hospitals that are not in the Franciscan system. Medical director agreements, for one item, are different than physician employment agreements. We don't have those medical director agreements as yet, although we did submit to the court, I don't know that they're necessary for the resolution of this case, an agreed protective order that those could be produced by community hospital. That's the actual question. His Honor has not signed that order yet, so we don't have those materials. That's okay. I don't know that they're necessary. what medical director agreements aren't for is being in an office seeing patients on a daily basis, being in a hospital seeing patients on a daily basis. Medical director agreements provide policy, cheerlead for the hospital. I'm a medical director of infectious disease. This is what I do. This is my job. I'm going to set policy on how we treat MRSA, what patients relate into the hospital, things along those lines. But, Your Honor, those agreements to provide medical director services were sold to Franciscan by their own agreement. So they claim protection under those. There's no protection at all. If they're suddenly giving them back and waiving all their non-competes and doing all this just to save this lawsuit, that's not effective. Your Honor, there's a section of our reply brief at page 11 that I think is a telling paragraph exactly in this regard. It's under the paragraph, equity regards substance over form. It's on page 10. The substance of the agreement between medical specialists and Franciscan is to provide Franciscan with the means to restrain the plaintiffs from competing, which Indiana law does not allow. On page 11, reads, likewise, medical specialists sold all of its significant tangible and intangible assets and agreed not to compete within 25 miles of its main office. There's no way that its competitive interest could be harmed by the plaintiffs under these circumstances, because even though it maintained its existence as a corporation, it was not a competitive enterprise. Not on October 1st, 2012, when these men and this lady had to make a decision. What do we do? 7 months later, 2 days before my summary judgment response is due, I'm going to fix that. I don't think that's fixable. Now medical specialist claims that it needs the court to protect its business goodwill and the plaintiffs. The 7 months after the asset agreement closed, Franciscan has partially waived the covenant not to compete, has licensed some of the goodwill that it purchased back from medical specialists. There's no substance to the transaction other than to provide Franciscan with the means to prevent the plaintiffs from competing. The law doesn't allow this. Again, citing this, Your Honor cites the Reamer decision. I think I cited earlier to the court. I will hand up a copy of that before the argument is over. The Reamer says an asset purchaser may not enforce covenants not to compete in a predecessor's employment contracts. Then we've got the case of Field versus Alexander and Alexander of Indiana, Inc., 503 Northeast 2nd, 627, Court of Appeals, 1987. Covenant not to compete must anticipate a possible injury the employer would suffer at the hands of a former employee, as opposed to merely preventing an employee from competing in the workplace in the future. In other words, you don't just set something up to stop someone from competing. You must have a legitimate protective interest. Here, I don't think Your Honor that we have that. The second, Your Honor, independent ground for the court to consider is the fact that there is a substantial public interest and public policy concern in having these particular positions because, for good reason, they are specialists in what they do. The people they treat are often gravely ill. And, Your Honor, that this area of the country, of the state, and actually of the county where these doctors all work is a medically underserved area. We've provided the government statistics that we believe the court can take judicial notice of, and it can, that state that this is a medically underserved area. And quite frankly, Dr. Stemmer, former president of medical specialists, he's now highly vice executive of the Franciscan Alliance, or Franciscan Medical Specialists, how many different entities, large organization. Dr. Stemmer, in order to bring physicians here from outside the United States, on many occasions, from at least that I know of from the early 2000s forward to as recently as January of this year, has made the statement that this is a medically underserved area, that we need these specialists. Words like catastrophe could ensue. I can't bring this doctor here. That's how Dr. Layous got here. That's also how Dr. Atassi got here. the United States. You're allowed to get a J-1 visa waiver if you're coming to the United States to serve a medically underserved area. In other words, the United States, our medical schools, our healthcare system, we cannot produce enough doctors or specialists to handle the population or the illness of the population in this area. You can receive a waiver, you can come to the United States and eventually gain your citizenship. Now Dr. Stemmer says, well, that was a while ago. This was a couple years ago, this was 5 years ago, this was 3 years ago. That situation doesn't exist anymore. Why? Because it suits my purposes now. Okay? And I'm going to show you why. Now, Dr. Stemmer submitted a lengthy affirmation in this case, and it is contained at Exhibit A, specifically paragraph 12. I'm sorry, page 12, paragraph 33. Dr. Stemmer, in his declaration to this court, states, my opinion that there is no shortage of physicians specializing in pulmonary diseases in Lake County is supported by the fact that there is no appreciable wait time for a patient seeking evaluation and treatment by a pulmonary diseases physician. A patient who wants to see a specialist in pulmonary diseases can receive an appointment within 1 day. And that is, Your Honor, actually there's going to be 2 paragraph 33s. One is on the bottom of page 12 and one is on the top of page 13. They read the same except the one on page 12 is cut off. I'm sorry, the one on top of 13. Can receive an appointment within 1 day of requesting an appointment at the Franciscan Medical Specialist Muster Office, and the same day as requesting an appointment at the Franciscan Medical Specialist Cabinet Office. Also says there are sufficient, in paragraph 34, there are sufficient physicians specializing in allergy and immunology in Lake County, Indiana. The medical specialist intends to hire Dr. Dennis Rademacher, DO, to replace Dr. Patel. At the time, Dr. Patel's contract with medical specialist expires on June 30th, 2013. It says the same thing about infectious disease specialists in paragraph 26. Now, because it's been so long since Dr. Stemmer wrote those letters to the government saying why he needed J-1 visa waivers to get doctors here, we received and filed yesterday whether the court will consider it, and I think it's still an issue for the court to decide. But we received from Ms. Natalie Brown at the Indiana Primary Health Care Association, that's where applications are submitted to assist in getting J-1 visa waivers approved, a letter from Dr. Stemmer, which is attached as Exhibit Double F. We're trying to keep in line with our multiple lettered exhibits that we've submitted so far. Exhibit Double F. Mind you, this was written not quite 6 months ago. This is written for Dr. Yasser, January 25th, 2013. Dr. Yasser's employment will satisfy important unmet health care needs in Lake County, Indiana, which contains the medically underserved area of Hampton. This community shares the demographic factors of poverty, absence of health resources, and the heavy burden of untreated disease. Lake County, Indiana continues to be dangerously short of trained internal medicine, infectious disease physicians who are capable of and willing to assume the care and responsibility of local population, which consists of a disproportionate number of patients who suffer from conditions including pneumonia, HIV, tuberculosis, and the new epidemic of community-acquired methicillin-resistant Staphylococcus aureus, which is MRSA. These patients tend to be on Medicaid, Medicare, or are uninsured. I find it interesting, I hope the court finds it interesting, I think it will, that Dr. Stemmer, the main applicant to the entire designation of evidence, supplied by medical specialists in his defense, says one thing on March 22nd or 24th, the day that the brief was filed, and says something exactly in opposite of that said something exactly the opposite of that 3 months earlier, in January of 2013. It's at least disturbing. But, Your Honor, I think that the defense has also pointed out that while Lake County, Indiana, or the northwest portion of Indiana may have, in some cases and in some specialties, more than the national average per 100,000 population of doctors in particular specialties, what they do not take into account anywhere in making that assessment of what is the public need in this area is the higher rate of certain diseases. We are replete, as Your Honor knows, with factories, refineries, steel-producing facilities. We have a much heavier population of smokers than most places in the country. Don't ask me why. If it's the hard work, if it's whatever it was, it's how you grew up. It is what it is. But those factors aren't taken into account. In fact, these are the items that were unchallenged from our designation of evidence, and they start out, Your Honor, on page 17 of our reply brief, regarding what is medical care in Northwest Indiana. It's page 17 of our reply. The following facts are undisputed after the defendant's submission. There are 76,886 Medicare beneficiaries in the country. In the county. Over 21% of Lake County residents, that's 106,076 persons, are Medicaid beneficiaries. As of July of 2012, the northern half of the county contained 2 federally qualified health centers. It's Exhibit D5. There are 4 federally designated medically underserved areas in the northern part of the county. That is unchanged. The medically underserved area designation is based on the Index of Medical Underservice, IMU, what it's called. The IMU is calculated on several factors and ranges from 0, which is completely underserved, to 100, best served. An IMU less than or equal to 62 qualifies for an MUA designation. There are 4 factors which are assigned a weight score to determine an area's IMU. Percentage of population below the poverty level, percentage of population age 65 and older, infant mortality rates, and the ratio of primary care physicians per 1,000 population. That is also a government statistic. The populations of both Porter County and LaPorte County both are designated medically underserved populations. Dr. Stemmer offers nothing in his affirmation to dispute this, and nothing concerning Porter County or LaPorte County whatsoever. All of the plaintiffs plan on accepting insured, medically indigent, Medicare, Medicaid, and sliding fee scale and uninsured patients. The defendants designate no evidence to challenge this fact. The county compares unfavorably to U.S. and peer county benchmarks for many chronic health conditions, including coronary heart disease, lung cancer, and stroke. Lake County ranked the stellar 84th of 92 counties in the state for overall health outcomes, like length of life and quality of life. Lake County ranked 82nd out of 92 counties in the state for overall health-related factors like smoking prevalence, alcohol consumption, access to medical care, quality of care, economic status, and physical environment. Those factors went unchallenged, Your Honor. And to take 5 well-trained, highly educated specialists out of this area, even 10 miles away from where they used to practice. Now, before I think it would be a terrible disservice to the population of this whole county, and certainly to those areas where they practice. But let me tell you, before I get into that, how the non-competes work. I should have talked about that earlier. Except for Dr. Jordan, that I'll talk about, each of the 4 physicians seated there, their 10-mile radius of their non-compete goes to every location they've ever practiced for medical specialists. Every hospital they've been to, each doctor's office they've practiced at. We've attached in our designation a relatively, hopefully accurate 10-mile radius of each place where the physicians work. Now, that 10-mile radius only extends 3 miles into Illinois. So if you've got a 10-mile circle, it's supposed to go kind of like an oval into Illinois. We didn't do that in our designation. I apologize. But none of the doctors practice in Illinois anyway. It's not where their patient base is. It's not where they practice. So when you take all those 10-mile radiuses and put them together, For most of the doctors, it's the entire northern portion and mostly the eastern portions of the county. Dr. Atassi, for example, is an infectious disease doctor. 90% of his practice, and so he's testified in deposition, is conducted at hospitals and not at medical offices. Dr. Atassi has covered every hospital from here to LaPorte. Dr. Atassi's 10-mile radius is a lot more like 100-mile radius. Okay? The only radius that's different is Dr. Jordan's radius. Dr. Jordan's radius was only a 10-mile radius from where she worked formerly for medical specialists at Calumet Avenue and Main Street in Munster, Indiana. Dr. Jordan is currently practicing in Maryville, Indiana, where she does not care to be where her patients are not. They don't care to come there. They're coming there to see her. They're very difficult. Frankly, she's not here today because of that fact. She's trying to get her own practice up on her feet. She's got a lot of procedure schedule. She's trying to catch up and be here. That's what we wanted to be here. But her radius is different. That was something she negotiated for before she'd ever signed a contract. Different attorney handled that. I don't know why it was done, but it was done. So in any event, Your Honor, with what the health statistics are here, with what I think we all know from our common experience is the difficulty of finding quality, high quality, willing, able medical care in this area. Especially, maybe not so much, right downtown West Indiana Community Hospital, East Chicago, Hammond, Gary, Harbor. Not easy to find. And we want to take 5 professionals and eliminate them from this area. That cannot serve the public interest. It is a disservice to the public interest. And it is a disservice to the patients who these doctors already treat. Doctors Layous and Secchi have seen in the last year, they estimate well in excess of 1,000 patients. Those patients have chronic health conditions. You don't get referred to a pulmonologist, like I think I said earlier, because you have a cold. You get referred to a pulmonologist because you have what potentially is a chronic lifelong condition that needs to be treated on a regular basis. Dr. Atassi's patient base that he sees in office where we'd no longer be able to go. Primarily HIV and AIDS patients. They have to be on a very specific regimen of medicines. Inhibitors, you name it, constantly being adjusted, they constantly need to be seen. Dr. Atassi won't be able to see them. Unless they're willing to pick themselves up and go find Dr. Atassi somewhere else. And I don't think that fosters, what I would consider to be high quality patient care. And that's one of the things that the Supreme Court stated and the Court of Appeals stated, and that's in our brief, about why these agreements have to be looked at with such closer scrutiny. What we don't want to do is take the patients and stifle their communication with their doctors. We don't want to drive them away from one physician into another physician's arms. People should have the choice. They should be able to see who they want to see. And I think that, especially in this area with the limits that we have, it would be unfair to the populace and bad public policy to, for lack of a better way to put it, pick them out. Now that's the second factor in the 3-factor test. The third independent reason, I shouldn't consider factor test, it's not a factor test. The third wholly independent reason that we state that the covenant should not be enforceable is the fact that the moment the asset purchase agreement was signed, the contracts were reached. I shouldn't say everyone's, the 5 physicians, plaintiffs in this case, ceased, in my opinion, and I think the briefs show that, to work for medical specialists. They got a paycheck from medical specialists. I understand medical specialists' name on it. I understand Franciscan Alliance did the billing and collection, get all the money that they earned, and gave medical specialists just enough money to write paychecks with, rather than writing them giving them a Franciscan check that they definitely did not work for. Medical specialists gave them a check. Every employee they work with used to work for medical specialists, now works for Franciscan. Every piece of equipment they touch now belongs to Franciscan, not medical specialists. Every computer they type on, chair they sit. Patient that they see, that patient file that they open, be it on computer or on paper, belongs to Franciscan. We think that, Your Honor, is not working for a medium-sized independent specialist healthcare provider. That is working for multi-billion-dollar 13 hospital system. It's something very different. Medical specialist was also required, as part of the contract, to provide health care benefits to their employees, to the physician employees anyway. Dr. Sethi was true to his wife's policy. The other doctors required health care plans. When they received calls and emails regarding renewal of their health care plan, it was from a Franciscan Alliance employee. That Franciscan Alliance employee forwarded forms we included in our designation that state specifically they are eligible to receive the health care plans from the provider because they work with Franciscan Alliance, and it's Franciscan Alliance's plan. Well, a couple of problems with signing that form. One, could be found by the court to be an admission. If we sign it, we're saying, hey, I guess we work for Franciscan. Also, if we sign it and we know we don't work there, which of course we've always maintained that we never have, I'm not sure we're not committing a crime. Saying that I'm deserving of health care from an organization that I don't work for, I think is a substantial problem. So we refuse to sign it. Each physician that couldn't get the health care plan through medical specialists went and bought their own. Or were covered on the spouse's policy already. That is likewise a material breach. I apologize, Your Honor, I got to find this question. Also, Your Honor, and there's been some controversy about this, most of the depositions and filings and otherwise, I don't know that it's a critical issue. But in working in Franciscan facilities, which we certainly were working in, and in taking direction for scheduling and employees and everything else from the Franciscan folks, Franciscan also has ethical and religious directives. The buyer is a Catholic organization and conducts its business and operations in compliance with the ethical and religious directives for Catholic healthcare services is promulgated and amended from time to time by the United States Conference of Catholic Bishops or its successor, and is interpreted by the local bishop from time to time the directives. As of closing, each of the providers will be required to conduct their practices in conformity with the directives while working within the scope of their employment with the buyer. Now, we maintain we were never employed by the buyer. So, I haven't heard any doctors tell me these religious directives have been forced upon them. I don't know that that's necessarily the issue, but I don't know how good the employees were on that. But at any rate, the doctors, I have not heard the complaints from them about that. I think that issue is probably a non-starter. I don't think they're let ethical and religious directives get us to where we need to be. I don't think it constitutes a breach now that I've seen the deposition testimony and I've seen the testimony of other people in the system, including Dr. Stemmer. I don't think these directives were forced down your throat. Mainly they deal with contraception, abortion, and things like that. It is only worthy of pointing out that that is one of the reasons they didn't choose to go with Franciscan. I don't think that the religious directives or ethical concerns of the Catholic Church should be forced down the throats of anybody who's not Catholic. The four men over there are not Catholic, and they've so stated in their declarations. So now we've got, I don't want to go over anything too many times. We've got the three separate issues. The fact that the asset purchase, that there is no protectable interest. I think I've tried to highlight the most. Public policy concerns, the interests of the patients in being able to obtain health care, the fact that it's a medically underserved area, the fact that Dr. Stemmer, I think, has told the court something different from what he's told the government as to whether this is an underserved area and more doctors are needed here. And the fact that the breached contract cannot be enforced. The breaching party cannot enforce any part of the contract, including the covenants now. Any one of those three items is enough to get the plaintiffs where they need to be. I don't believe they should be held through non-compete provisions, the non-solicitation provisions. I think their contracts are nullity. the date they signed that asset purchase. I think Franciscan knew exactly what they were paying $23 million for. They weren't getting these doctors. I think medical specialists knew exactly what it was getting $23 million for. The practice doctor Zimmerman spent a lifetime building. It's an American dream. He got it, and he got what he deserved. But they don't deserve it to be limited where they can practice. Thank you.
Before we, Mr. Jones, let's take 5 minutes before we start it already.
All rise. You got it, Karen?